Hi, this is Josh Blackman. Welcome to the 2025 Harlan Institute Moot Court Competition. This year we're arguing the case of Free Speech Coalition v. Paxson. This is match number one, the semifinal round. Petitions begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Shayla Bergen, and with my partner, Emmy Maeda, we will be representing the petitioners in today's case. Today's case presents the issue of Texas Law HB 1181, a statute that requires websites containing one-third or more of sexual content harmful to minors to verify the ages of all users, including adults. The question presented is whether the court should apply strict scrutiny or rational basis. Justice Kennedy stated in Ashcroft versus ACLU that content-based prohibitions have the constant potential to be a repressive force in the lives and thoughts of a free people. The respondents threatened to do just that by restricting adults' access to constitutionally protected speech under the guise of protecting children. This court should reverse the Fifth Circuit decision for three main reasons. First, HB 1181 is a content-based restriction subject to strict scrutiny. This court affirmed in precedents Reno versus ACLU, Ashcroft versus ACLU, United States versus Playboy, and others that content-based restrictions require strict scrutiny, a standard HB 1181 does not meet, as the law is not narrowly tailored and fails to consider less restrictive alternatives like content filtering systems to accomplish the government's interest.
And in doing so, the Fifth Circuit decision departs from precedent and far overextends Ginsburg v. New York's purview. Second, the law is also over and under inclusive. Social media platforms and search engines host harmful sexual content, but would not be regulated since it does not fulfill the one-third threshold, making the law under inclusive. At the same time, it's over inclusive in that just one-third of sexual content on a website can warrant restricting two-thirds of constitutionally protected speech. And finally, the law unconstitutionally compels unscientific and stigmatizing speech that may deter users from accessing protected speech. These disclosure requirements are both unjustified and unduly burdensome.
So let me just ask a question, please. What is the appropriate standard of review to review this Texas law?
Your Honor, the appropriate standard of review is to look at precedents, for example, ACLU v. Ashcroft and Reno and United States v. Playboy to decide that this is a strict scrutiny case.
Okay. So why do you think strict scrutiny should be applied here rather than intermediate scrutiny?
Because this is a content-based restriction on constitutionally protected speech of adults.
Yes, we see that this law is specifically singling out sexual content that is harmful to minors, and that is by definition a content-based imposition. We've seen very similar things happen.
Counselor, is this just a restriction on the speech of adults? Isn't this also about children?
Your Honor, this may also be about children, but the case we're bringing today is that it's burdening the speech of adults. And that's really what we need to focus on in order when we're applying strict scrutiny, because the fact that these privacy concerns, these immense privacy concerns that are brought up by HB 1181 would severely chill and burden the speech of adults. For example, this is a very similar thing that happened.
Counselor, can I ask a question? So how exactly does it burden the adult's speech, or how exactly does it chill their speech?
So there are pretty extreme chilling effects when it comes to submitting federal identification online. There are large privacy concerns concerning, an adult having to give their information to a third-party service, especially when accessing such sensitive content. And so the fact that there are privacy concerns in this is going to cause adults to not access content that they are constitutionally entitled to. So there have been hacks before of third-party identification programs, and it doesn't matter, how secure of a company, how big of a company. There's always the possibility that these companies could be hacked. And so,
yes. And the burdens it imposes on adults on the internet is far different from the burdens it imposes in a traditional brick and mortar store, because when adults submit their information online that may go on a permanent record, it also opens them up to malware attacks or DDoS attacks, things that simply don't happen in traditional brick and mortar stores.
Can I ask a question, please? I mean, maybe you watched Super Bowl last night, maybe didn't. There are all these commercials for online gambling, right? And to do online gambling, you have to be a certain age. And, millions of Americans submit whatever verification is needed to engage in online gambling. Why is this any more burdensome?
Your Honor, it's more burdensome. First of all, I think because of the stigma associated with the content that they might be accessing. The content like pornography websites are and sexual preferences are very private to the individual and not as burdensome as asking private information when it comes to gambling, etc.
Mm-hmm. But the burden is just showing your information. It's not what kind of pornography you want to obtain. Why is it? In other words, why does it matter whether you're verifying your age for gambling or verifying your age for pornography? I'm not too much. What's the difference?
I think the difference is that people don't have a constitutionally protected right to gamble, but people do have a constitutionally protected right to access constitutionally protected speech, as the First Amendment says. And
Okay,
the
so
fact, yes.
Okay, go. I'm sorry to interrupt. Go ahead, Counselor.
Thank you. And to continue, these disclosure requirements are both unjustified and unduly burdensome. Therefore, we ask the court to apply strict scrutiny and overturn the Fifth Circuit decision and reinstate the preliminary injunction issued by the district court. And furthermore, if we want to talk about the less restrictive.
Counselor? Yeah.
Can I ask another question? So how exactly is content filtering designed to prevent circumvention of, or how exactly is content filtering designed in a way that you're saying Texas, their law right now, kids can get around, they can have a VPN. How exactly is content filtering going to be better?
So first of all, content filtering is less restrictive. So even if it is as effective of age, or if it's the same amount of effectiveness as age verification, it's still a better option. But there are methods that you can use to download content filtering systems on the hardware of a device, meaning that they can't be circumvented via VPN, whereas age verification measures can be.
Yes. And the thing about content filtering systems is that as technology has evolved and maybe the amount of online pornography has evolved, at the same time, these content filtering systems have been designed better and better to withstand circumvention. So we see these being implemented in school Wi-Fi's and libraries. In fact, we're using school Wi-Fi right now, and in our experience, we can tell you that there are a lot of things we can't access because of the content filtering systems imposed by our schools. And that includes
a quick question about that. I'm sorry. So you mentioned that content restrictions and content moderation systems have improved in like the 20 past years. I think it's also true that the ways of circumventing and getting around that, the pervasiveness of pornography has also increased. Of you can potentially access or be exposed unwittingly to pornography on your iPad or your video game console, your phone. Do you think that poses a problem for your position?
No, Your Honor, I don't think it poses a problem for our position because, as you mentioned, these content filtering systems are getting better. And as my co-counsel said, by implementing them on the device, they are much more difficult for the students, or excuse me, the minors to circumvent. And also, Your Honor, I'd raise the point that as technology has evolved, it also makes age verification possibility of malware attacks when it comes to age verification technologies much more pervasive and dangerous. So if we're talking about the evolution of technology, we should also consider the danger of age verification technologies and softwares. Yes.
As my co-counsel said, as content filters have evolved, as age verification has evolved, malware attacks and hacking has also evolved immensely, and content filters are something that aren't as susceptible to hacking and malicious entities as age verification would be. So it's a better alternative.
Okay. And I apologize, I forgot to turn your timer on, but you do have 30 seconds left. I just remembered a moment ago. So if you can just wrap up, please, go ahead.
Thank you. In conclusion, the argument that our friends on the other side makes are reliant on the honestly very frail basis of Ginsburg. But we give you precedents, that's ACLU, Ashcroft, etc., that say we must apply strict scrutiny to content-based impositions, and that principle has not changed ever.
Wow, that is really dramatic and obnoxious. Oh my God, I have to stop that.
I liked it. It was like Star Wars.
Yeah, majestic.
Okay, I'm just gonna, let's see. How's that sound? Time's up. Okay.
All right, thank you.
Thanks.
Okay, let's keep it simple. Okay, beep, beep, beep. Okay. All right. I'm sorry about that. Let's go to you guys are such good sports. Thank you. 15 minutes for respondents. Whenever you're ready, you can begin, and you have your 2 minutes for opening remarks. Thank you.
Mr. Chief Justice, and may it please the court, I'm Olivia Migrant, and this is Josie Weiner, and we're respondents in the case Free Speech Coalition v. Paxton. This court should find that Free Speech Coalition v. Paxton, under House Bill 1181, should be reviewed under the rational basis standard for free speech. Our main reasons being that Ginsburg is the controlling precedent and should be applied. This bill does not apply blanket bans, and the bill does not include content-based restrictions. Ginsburg is the controlling precedent because it was the first case established pertaining to kids accessing pornography. It was decided in 1968, whereas the newer cases like Ashcroft v. Free Speech Coalition occurred in the 2000s, but they did not abrogate the decision in Ginsburg v. New York. Therefore, due to the stare decisis doctrine, Ginsburg is the correct case to apply. And it also, in this case, they applied rational basis as their method of review, and therefore that is the method that should be used in our case as well.
In addition to what my co-counsel has said, the case of Free Speech Coalition v. Paxton, in House Bill 1181, it is not establishing a blanket ban on the speech. So any adults ages 18 and over have full access to the speech, provided they give a reasonable age verification, which this type of verification is used commonly throughout both just like face-to-face conversation as well as on the internet. So there are many other things that require, if you are purchasing something or if you are accessing other information, there are many other times and places where age verification is a reasonable request. So this is a very low burden just to access speech while protecting minors from speech that would be considered harmful to them.
Okay, Counselor, let me jump in. So I want to actually focus on your first point, and you are correct that Ginsburg came first, and it's an older case, and then there's more recent cases, for example, Playboy and Ashcroft and others. So you say under stare decisis we follow the earlier precedent. That's true enough, but what if it's possible to sort of reconcile the precedents? That in other words, they're both good law, right? It's not one is better than the other, and then maybe the issue is that in certain cases Ginsburg applies, in certain cases Ashcroft and Playboy apply. Maybe you can address how maybe we could read those two precedents to not be in conflict, but maybe to follow both of them at the same time.
Yes, well, yes, Your Honor. In this case, there is not a blanket ban on the speech, which is similar to that of Ginsburg, where they are trying to prevent minors from accessing this information in stores. So when there is a blanket ban, we should go to other cases like Playboy, United States v. Playboy, but in this situation, Ginsburg is the most appropriate.
So
to apply.
Ashcroft and Playboy only apply them as a blanket ban. Is that your position?
They are overly restrictive methods of preventing speech, and therefore they infringe upon First Amendment rights. However, in our case, the rights are not infringed upon because it is only asking for age verification technology.
Right. So the Texas law, what exactly is the burden? Your friends on the other side think it's really burdensome. I mean, how would you describe the burden of the Texas law?
We would classify the burden as very low because this is age verification. It's not an intrusive form of information about yourself. This is information that most people would provide readily. It's not something that a person would traditionally hide. It's something that it's on your driver's ID, it's on your driver's license. So it's something that a lot of people there are many situations where it is appropriate to ask for your age, and then this is a good example of when. And in addition, with the case, as we mentioned before with Playboy, the issue with Playboy is that it restricted speech to adults as well as children.
Hmm.
So by scrambling the communications, it was the speech that maybe some adults might want to see, even if, and in this case, the speech is something that's constitutionally protected for adults to see. They were restricted from seeing this as an overexpansion of the aim to protect minors from this speech as well. But with House Bill 1181, it's only restricting the access of minors to this speech. So it leaves provided like this, yes.
Counselor, if I could just jump in for a second. We know that as a result of this bill, a lot of internet sites have shut down, like Pornhub and others. They just shut down Texas. So even though it may not be on its face a blanket ban, isn't the effect of this law to shut down these sort of pornography sites altogether in various states that have these age laws?
That is not, no, Your Honor, that is not the intended impact of this bill. The
Well, I
bill,
agree. It's not the intended impact, but that's the effect, though. That's actually what's happened on the ground, and we can take notice of the fact that this has happened. Very often, a law might have one intent and a different effect. Can the courts only look at the intent and ignore what actually has happened, what the actual effect has been?
Your Honor, yes, I understand that the effect might be different than the intention, but that is not a result of the law itself. That is a result of if specific companies feel that they do not feel comfortable maybe keeping safe track of this information.
Right.
So
Well, they're worried about liability. They're worried if they operate in this state of Texas and they don't follow and then someone inadvertently accesses pornography with a child, then they might be subject to significant fine under the law. I mean, isn't that the issue that they've exited the market because they're afraid of liability? Isn't that the law has caused this behavior?
yes, Your Honor, it has caused this behavior. However, there is an important role of the government to protect children from this material, and that is what was done in Ginsburg, and it prevented kids from accessing this material. And so you have to balance the two needs, and if these companies truly want this material out there, then they have to follow the rules, and that they can find ways to adjust and possibly make sure that their adults can continue to access it. It's not a matter of adults not being able to access it, it's their own fear. So if they implement what is asked of them, then they should be free of that burden.
Thank you, Counselor.
Can I jump in for a second? If I understand the respondents and the arguments overall, I think everyone concedes that there's a compelling government interest in protecting children from access to pornography. At least my understanding is the real work is happening around whether this is narrowly tailored, or at least that's one route that we could strike this law down. Can you address the other side mentioned age verification software and how it's developed. Is that a proper view that age verification is actually fully protecting minors, that parents are well equipped to employ that technology in all of these contexts? I guess to phrase it slightly differently, do you think that age verification technology and content moderation specifically, does that mitigate the harms that are present in children accessing pornography?
yes, Your Honor. With the increasing use of technology and the increasing access of it by minors to the vast expanse of the internet, there's definitely an increased risk of minors encountering material that would be harmful to them. And then my apologies. The significance behind House Bill 1181 is that it is universally applicable to to all the minors who it would apply to within the state of Texas. The issue that I believe the petitioners brought up, which could have been a good point, but I noticed that they were talking about how parents have the ability to have hardware on within their own devices, so they would not need governmental governmental my apologies, governmental restrictions. But the issue is that, and this is also seen in I'm sorry, this is also seen in Playboy, is that
it leaves it up to the parents to make that decision, and it's not it won't allow everyone to have the same impact. And because of that, in Playboy, they struck it down and they said that and therefore that because parents were the ones deciding it, that it was not going to be allowed because it wouldn't be a consistent application. However, in this case, because the government is putting this onto the companies, it will be required for all, and it will prevent all children from being able to access this material, unlike content filtering, which could be installed on a device.
Counselor
I've got another follow-up question. Of earlier, you mentioned that in the context of the age verification, that this is information that most people are willing to answer. It's not a big deal if someone asks me how old I am. I respond and don't even have to think about it. Do you think there's any problem if instead of just that kind of question of uploading your driver's license or that sort of thing, is there any problem if Texas instead required that you do something like a passport or a retinal scan, or is there any problem if that was the approach the bill used?
Yes, Your Honor, I would see how it would be different for that, in that there are different ways of identification that are considered more invasive than others, I suppose. So in this case, age verification is a very low burden in comparison to something like your passport, which has your social security number and other details like that you would not readily give out.
And so I think that the problem I'm facing right now is that language you're using of the burden could increase, or that sort of thing. If we're applying rational basis, that doesn't seem to really matter, at least in how I understand rational basis. When the burden becomes increased, well, we're in the language of maybe intermediate scrutiny or strict scrutiny. Of how do you reconcile that?
Well, yes, Your Honor, but we would say that this information that they're requesting does not push that far, and that if that information were to be asked, then it could be reconsidered. However, at the minute, we use age verification in many other parts of our lives, and it is not considered an infringement. For example, IDs are asked for in a brick and mortar store for a pornography store, or for alcohol or other different types of things that are prohibited from minors accessing. Therefore, the burden is extremely low. And in this situation, we suggest that we should apply rational basis.
Counselor, is it not true that in Ginsburg, that the only reason that the court used rational basis scrutiny was because it was a child trying to assert his right to view the pornography, not it was the child, not the adult here, where the adult has that protected interest. That's why it would be strict scrutiny. Is Ginsburg not distinguishable because the child was asserting their right to view pornography?
No, Your Honor. In both situations, it has to do with kids accessing this material, and no matter who necessarily is asking it, it's important that they are protected and we're pertaining to their rights, and therefore the establishments in Ginsburg of different free speech rights for children versus adults would apply here equally, and Ginsburg pertains to this case.
Let me ask you a question. Do you see a difference between a clerk at a store asking for a driver's license versus some sort of online system that stores that information in the cloud, perhaps forever, and it can be used, for some, malicious purposes? Your friend said, it's embarrassing or compromising that someone wants to look at porn online. Do you see a difference as, clerk at the store says, oh yeah, sure, your license, okay, that looks fine, versus retaining the information?
Your Honor, yes, I do understand where you're coming from. However, in Texas House Bill 1181, there's a specific provision establishing the consequences or establishing the precedent that they must clear their data, remove this data from any place that they might store it within a certain amount of time, and if not, they will face severe.
I know that, but look, you know about data leaks. I know about data leaks. Stuff, once it's in the cloud, who the heck knows where it is? Isn't that, though, from a First Amendment perspective, shouldn't that matter a little bit, to say that even putting this information in the cloud is different and might chill speech and chill protected behavior? I mean, people do have a right to access pornography. The Supreme Court said this.
Yes, Your Honor, I do understand that. I would also like to point out the fact that I do not see a significant difference there's also the possibility that someone can see you if you walk into a pornography store. So it's not as if by walking into it, nobody knows you're there. There's like, you might see someone else, you might see someone on your way. Someone might see you with this information. So it's not in that you're hiding it necessarily by going to a physical store to see this information versus seeing it online.
Okay, thank you, Counselor. You're about at 40 seconds. You can wrap up.
We would just like to say that in conclusion, based on all of the precedents we've established, primarily following the precedent established by Ginsburg, that Texas House Bill 1181 under Free Speech Coalition v. Paxton should be reviewed under rational basis.
Okay, thank you so much, Counselor. All right, 5 minutes for the petitioner whenever you're ready.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. So, two things. First of all, our friends on the other side say in their oral argument, and they write in their brief, that adults' rights are not negatively impacted by Texas law HB 1181. And that's simply not true. And precedents like American Booksellers Foundation versus Dean admit that online age verification requirements trigger a chilling effect that would burden adults who access and publish the information and reduce the adult population to only what is fit for children. Additionally, here, as they were being questioned, they mentioned that a reason why Pornhub may have closed down in Texas is because they didn't feel secure holding the identification of adults. And so if these companies can't feel secure holding the identification of adults, how is it reasonable to expect an adult accessing sensitive content to upload their information? And so additionally, yes.
And additionally, we'd also like to touch on Ginsburg and the respondents' attention to that. But one thing we'd like to mention is that Ginsburg doesn't condone such a broad age verification requirement, and we haven't seen that from Ginsburg. For example, the 1/3 threshold from HB 1181, it does not exist in Ginsburg. In Ginsburg, it was never that in these brick and mortar stores, minors are prohibited from entering stores that have 1/3 or more, say, girly magazines. They can still access the 2/3 of constitutionally protected speech in the same store. So this 1/3 threshold completely derails us from being able to apply Ginsburg.
Let me ask you a question. Is this material, how do you reconcile Miller versus California and obscenity with Ginsburg? How do you line these two cases up?
Yes, Your Honor. We believe that HB 1181 does borrow language from Miller, but that does not exempt it from being overbroad. The key difference is that Miller, it was a case about obscenity for adults, but in HB 1181, it says sexual content harmful to minors. And we think that to minors immediately differentiates this from the Miller test and could even mean that we're restricting content. For example, movies like Marlon Brando movies, I believe was brought up in the Fifth Circuit decision. Even those movies that have value would be restricted because those could be considered sexual content that is harmful to minors. Thank you. And furthermore,
Yeah. So the New York law said that if there was a knowing sale to a minor of, like obscenity, someone who the seller should suspect to be a minor, that was the exceptional instance where you might have, subject to the seller's discretion, made a reasonable attempt to ascertain the age of the minor. So the Ginsburg law was actually more narrowly tailored because the identification was only being taken of people who were suspected of being a minor. So not every adult who entered Ginsburg's store and tried to buy a girly magazine would have their identification taken.
Yes, so that's a big difference between HB 1181, where all people, regardless of whether they're suspected to be a minor, need to be verified. And
can I ask a quick question? So, but isn't it true that in the Fifth Circuit's decision, they discussed the possibility of using like biometric data, which wouldn't really compromise any of your personal information? For example, if you just show a hand and can prove your age, and then you don't have to give them your name and date of birth and address and the same things that would be on a government issued ID.
Sure. I think the problem there, perhaps you're bringing up Yodi or something, but I think the problem there is that there have still been data leaks of these third-party age verification resources. And when it comes to biometrics, that means these users are being asked to, enter fingerprints or their own faces. And that would still do a lot to chill the users and deter these users from ever accessing this speech, because the very idea of having to go through all of that age verification to access this speech is incredibly chilling. To finish off, if
Yeah,
we may, thank you.
please.
To finish off, according to precedent and according to the standard of review, we should be considering ACLU v. Ashcroft and applying strict scrutiny to this content-based imposition. Therefore, we ask the court to overturn the Fifth Circuit decision, apply strict scrutiny, and reissue the district court's preliminary injunction. Thank you very much.
Thank you.
Okay, thank you so much. That was excellent. All right, let me turn off the timer before, let's see how it sounds. That's fine. Anyway, congratulations to the two teams. You've set a very high bar because this is the first round we've judged. That was excellent on both sides. You are polished beyond your years. You don't even know how polished you are. You're sitting here arguing about Supreme Court cases decided decades ago and how to reconcile lines of precedent. You're arguing about line between protected speech and obscenity. You're arguing about the burdens, the chilling effect imposed by various speech restrictions. These are sophisticated concepts that most high school students don't know about. Most college students don't know about. Robbie, Addie, a lot of law students don't even know about.
Yeah.
They're smiling, so I take that as a yes. It's very impressive. Also, I think the four of you collectively have a very good rapport. I think both teams work well together, and you sort of hand off from one to the other pretty naturally. You kind of you go right. You can make that a little more subtle, but I think you have a good rapport. And I don't think in either case one member dominated over the other one. Sometimes it happens where the one person talks a lot more. I haven't looked at it carefully. I think it was probably close to 50-50, if not 50-50, pretty close to it. You were responsive to our questions. And you did something that's really hard, is that when you ask a question from a judge, you just shut up immediately. You have to stop talking right away. That's a skill that I don't think I've ever quite learned. You got the moot court champions next to me, so maybe they know it. But I never quite learned that one. But you shut up, and it's very hard to do, but you did it well. And I think you're responsive too. And a couple of times, I think maybe you didn't quite understand the question, and you kind of said not really sure. You can do that. You say, Your Honor, I'm not sure. Questions aren't always good. Sometimes questions just are poorly framed, and it's almost dangerous to answer a question you don't understand, because you might accidentally walk into a point that you didn't want to make. You say, wait a minute, did you just say X, Y, Z? I thought your point was A, B, C. You say, oh, I was answering a question. Well, then you're toast, right? So that was actually very good. You all had good decorum. You say yes, Your Honor, no, Your Honor. I didn't hear any were there any maybes? I don't think I heard any maybes.
I don't think so.
No, that's good. The maybes are the answers you don't want to give. So I didn't hear any maybes, which is good. Did you hear a lot of maybe? Well, it depends, Your Honor. I didn't hear any of those, I don't think. Yeah, this was just really mature and sophisticated and polished. This is, I know this is the semifinal round, but this was at the quality of a much later round. And anyway, so I commend you all. Maddie, anything you want to add? And then I'll go to Robbie.
I thought y'all did an excellent job. Y'all are definitely beyond your years. I mean, y'all are all very poised, very well spoken. I'm very impressive that y'all are doing this at this age. So y'all should definitely keep it up. Another thing I thought that y'all did really great at was there something that I didn't learn till law school moot court, but the yes/no rephrase, which is when a justice asks you a question, you want to say either yes or no, and then or rephrase the question. You want to make sure that you're directly addressing what they asked you, and I think that y'all actually did a really good job of that, instead of just kind of saying what just moving to something else or saying something that you could say. I thought y'all were very responsive to our questions. Great eye contact. I thought everyone was great voices, and yeah, I think y'all have a very, very bright future ahead of you.
Yeah, that's for sure. That's for sure. Robbie, you have any comments for the students?
I'll spare being repetitive because my sentences are largely the same. I do moot court at UNC, and I would take any of you all on my team of just It's hard to find people who can do this. What seems, and at least viewing it, it seems very natural for y'all. I'm sure that a lot of work went into this, but you come across as very natural. I definitely echo what Professor Blackman mentioned of oftentimes questions are bad, of people are spontaneously coming up with these. And so it can be a little bit of like, oh, I wanted to ask about that, but then they're moving back and forth. So give yourself a moment and think through the question. And if you don't understand, definitely voice that or express that somehow. But yeah, that was absolutely fantastic.
Yeah, really, really, truly great. What questions do you have for us? Happy to answer any questions.
Then I have a question. This was kind of something I was battling last night,
Oh,
but this whole
yeah.
thing about Section 230 and how it might apply to this law. I know the Fifth Circuit Court decision kind of touched on this, but I was kind of wondering, and the writ of cert didn't really touch on it, so I was wondering if you have any insights on that.
Yeah, I mean, Section 230 is a tricky one because, like, does it provide a sort of safe harbor protection for the online companies? And there's also the what's called preemption issue. That is, if there's a federal law, does it trump the state law? I wouldn't worry too much about it, to be honest with you. I would focus more on the First Amendment issue. In fact, the reason why, every I write this competition and I write it in a way I hope as narrow as possible, because I don't want I don't want students to sort of run around and, like, make all these other points, but invariably they do because they're so smart. So what I would just say is uh, focus on the scrutiny issue. If the judge asks you about it, you can sort of address it, but I don't think it should be a primary part of your talk.
That sounds good. Thank you. Yeah, I remembered it from last year's Moody v. Net Choice, and I was
Oh, that's funny. You're right. It was the same issue last year, wasn't it? I didn't think about that. You're right.
it was quite a bit, yeah. So
Yeah. Let's see what other questions you have. Anything from my friends in Oregon?
No, so
How'd you find this? You haven't done this before. Was this hard? Was this tricky for you?
it took a lot of work. Yeah.
Well, I can tell it shows. I know it's definitely a lot of work, but you guys all did very well.
Thank you.
Hope you all consider law school. I hope you all are able to sort of think about your next path, but you all have bright futures ahead of you, I have no doubt.
South Texas College of Law.
Yes, I will give the plug anytime. I'm very, very proud of our teach and my students going to do great things. And UNC is good also. I think
I'm outnumbered in the present room, but UNC is fantastic and very affordable.
oh, very true.
still a while ahead of us, but we'll remember that.
All right, that's all I got. All right, you two, if you want to return the recording, if you sign off, I'll talk to the judges for a bit, and then we will next match about 20 minutes. Thank you all so much.
Thank you so much.